Judgment in the matter of Navigators Insurance Company Limited and others versus Atlasnavios-Navegacao LDA.
The question on this appeal is whether the owners of a vessel called the B Atlantic can recover for her loss from her war risks insurers. Unknown third parties strapped a parcel of cocaine to the vessel's hull in Venezuela in August 2007 with a view to its exportation in this way to Europe. The attempt was unsuccessful. The vessel was detained by Venezuelan authorities, and after 6 months, she was treated by her owners as a constructive total loss. The war risk cover was on the terms of the Institute War Strikes clauses. The perils insured, subject always to the exclusions hereinafter referred to, included loss of or damage to the vessel caused by a number of perils. One was capture, seizure, arrest, restraint, or detainment, and consequences thereof, or any attempt thereat, clause 1.2. Another was confiscation or expropriation, clause 1.6. And thirdly, and most importantly for this case, a third was by any terrorist or any person acting maliciously or from a political motive, clause 1.5. On the other hand, among the stipulated exclusions were arrest, restraint, detainment, confiscation, or expropriation by reason of infringement of any customs or trading regulations, clause 4.1.5. The words here, arrest, restraint, detainment, etc., mirroring, of course, closely those of clause 1.2 and clause 1.6, but not those of clause 1.5 referring to any person acting maliciously. So, the owners say they can rely on clause 1.5 and evade or avoid the impact of the exception in clause 4.1.5. Until the Supreme Court, it was common ground that the loss here occurred due to persons, the attempted smugglers, acting maliciously by strapping the cocaine to the hull. Further, one might think it was also reasonably apparent that an infringement of customs or trading regulations had occurred, and this too was common ground. But as I've said, owner's case is that while the exception in clause 4.1.5 may exclude cover in respect of any claim under clause 1.2 or 1.6, it is both linguistically and substantively inapplicable to the malicious acts coverage under clause 1.5. At trial, Mr. Justice Flo accepted the owner's case. The Court of Appeal reached the opposite conclusion. The owners appealed, and during the hearing before the Supreme Court, the Court concluded that it was necessary to re-examine the common ground that the attempted smugglers were, quote, acting maliciously within the meaning of clause 1.5. The parties made further written submissions on this point. The Supreme Court now unanimously upholds the Court of Appeal's decision. First, in its view, the vessel's loss was not caused by any person acting maliciously within the meaning of clause 1.5 of the Institute clauses. Second, even assuming that there was loss caused by a person acting maliciously, it was still excluded by clause 4.1.5. Lord Mance writes the judgment. As to acting maliciously, an element of spite, ill will, or the like is required, although this is not limited to conduct directed towards the insured interest. It could, for example, involve an act directed towards causing loss of or damage or injury to other property or a person, leading to consequential loss of or damage to an insured interest. Here, however, the attempted smuggling cannot be regarded as aimed at the detention of or any loss or damage to either the vessel or any property or person at all. Detection of the smuggled drugs and any consequent loss of or damage to the vessel were the exact opposite of the unknown smuggler's aim. Clause 1.5 must be read in its immediate context and in the light of the recent marine insurance authorities, which would have been in the mind of its drafters when the Institute clauses were issued on 1st October 1983. They were issued then to replace the hallowed but obscure Lloyd's SG policy form and to bring fresh order and clarity to many of the concepts used in the marine insurance market. Prior authority on the concept of persons acting maliciously is therefore relevant. There are two cases, both relatively recent in 1983, the Mandarin Star in 1968 and the Salem in 1982, established that for a person to be acting maliciously, an element of spite or ill will towards someone or something is required. Other authorities dealing with malice in a tortious context and Victorian criminal law statutes from 1861, referred to in some of the authorities later, do not provide helpful guidance to the meaning of any person acting maliciously in Clause 1.5. Turning to the operation of Clause 4.1.5, had it been possible to describe the attempted smugglers as acting maliciously within Clause 1.5, the appellant's claim would still have been excluded under Clause 4.1.5 as arising, at least concurrently, from detainment by reason of infringement of customs regulations. First, it would be surprising if an insured could improve its position by invoking one particular subclause of Clause 1, such as Clause 1.5, as opposed to Clauses 1.2 or 1.6, one or both of which would obviously also have been applicable perils in the present circumstances. Second, to establish a constructive total loss, the owners themselves needed to rely, and did rely, on a further clause, Clause 3, which deems a vessel a constructive total loss after 6 months following its capture, seizure, arrest, detainment, confiscation, or expropriation. To suggest that the exception in Clause 4.1.5 does not apply because it only covers capture, seizure, arrest, etc., and not malicious acts is therefore unpersuasive. Third, what is required is to give effect at each stage to the natural meaning of the words in this policy in their context. While the general aim in insurance law is to identify a single real, effective, or proximate cause of any loss, there may in some cases be two concurrent causes of loss. This is particularly so where an exception takes certain perils out of prima facie cover. And where an insured loss does arise from a combination of two clauses, one of which is insured, the other excluded, the exclusion prevents recovery. Here there are indeed two potential causes, namely the malicious act and the subsequent seizure and detainment for 6 months. Their combination was what was fatal for the vessel. The latter cause, the seizure and detainment, actually arose from the former, the excluded peril of infringement of customs regulations. The exclusion therefore applies, and the appellant's claim fails. The court will adjourn.